Welcome to this presentation of the Prevention of Smuggling of Migrants Act of 2018. My name is Andreas Schlohart, and for the next 10 or 15 minutes I will explain the main features of this act, the difference to previous legislation in force in Pakistan, and some of the central highlights concerning both those smuggling other migrants and the implications for the smuggled migrants themselves. Before this new act came into force in 2018, legislation was scattered around several statutes in Pakistan, while none of them particularly criminalized smuggling of migrants in the way in which the new legislation does. The Foreigners Act of 1946, for instance, had no definition and made no reference to smuggling of migrants, which means the facilitation of illegal entry of foreigners into Pakistan for profit. There was merely an offence of penalising facilitation of illegal entry without that profit element, and the penalty for this offence was also quite small. The Immigration Ordinance of 1979 criminalises the assisting or enabling Pakistani nationals to depart from Pakistan unlawfully. This criminalises in particular unlicensed labour migration from Pakistan to other countries. But this type of outbound smuggling is actually not an offence under international law. There is a further offence here in the Immigration Ordinance relating to fraudulent conduct that induces others to emigrate, which similarly has no equivalent in the laws of other countries and international law. If fraudulent documents are involved, then of course offences are available under the Penal Code, where, for instance, forged passports, forged visas are used to enter or leave the country or to achieve any other kind of service. What is important to note is that PACTO, the Prevention and Control of Human Trafficking Ordinance of 2002, which has been abolished in 2018, also was not and never applicable to the smuggling of migrants. Hence the need to legislate on this particular issue, and this occurred with the Prevention of Smuggling of Migrants Act in 2018. To give you some background on this statute, it is based in large parts on the United Nations Protocol against the smuggling of migrants by land, sea and air, which has been in existence since the year 2000 and has been ratified by countries worldwide. Based on this template, national laws in Pakistan were reviewed by the United Nations Office on Drugs and Crime, who then also became involved in drafting the new legislation. In June 2018, the new Prevention of Smuggling of Migrants Act was legislated and became the law of Pakistan. Its purpose is to provide for effective measures to prevent the smuggling of migrants by land, sea and air across Pakistan's borders. Further, its preamble states that it serves to promote and facilitate both national and international cooperation, and lastly and importantly, it also has a purpose to protect smuggled migrants. Its key features, which I will repeat multiple times throughout this short briefing, is to criminalize and punish organizers and smugglers who seek to profit from facilitating illegal entry into Pakistan. Furthermore, it serves to protect smuggled migrants and not to criminalize them. Smuggled migrants are object of this crime. They are not the subjects or the perpetrators of this statute. The term smuggling of migrants is new to Pakistani law, and it is defined in Section 2, paragraph I of this particular act. It is defined to mean the facilitation for benefit of illegal entry of another person who is either a foreigner, as defined in the Foreigners Act, or is a citizen of Pakistan, as specified in the Citizenship Act. Foreigners may be smuggled in or out of Pakistan or another country, while Pakistani nationals can only be smuggled out of Pakistan into another country, provided that neither the foreigner or the Pakistani has a right to enter that other country. This definition has four essential elements: the conduct of facilitation, the purpose, it is done for benefit, the result is the illegal entry, and the object is that other person who, as I said, is either a foreigner or a Pakistani national. Once again, the focus here is clearly on the smugglers who are seeking to profit from smuggling another person. The focus of this definition, of the offences, and of the entire act is not on the smuggled migrants. There's other terminology that is defined in this legislation, that some of which we've seen already in the definition of smuggling of migrants. The term benefit, for instance, is defined in Section 2, paragraph A, to include any monetary profit, proceeds, or payment in cash or in kind. It may include sexual favors, other gifts, and not just cash. Illegal entry is defined to mean crossing the border through any port or place other than a designated port or place, or without complying with the legal requirements for entering into Pakistan or another country. It could mean crossing the border outside the normal inspection points, but also using forged documents or failing to comply with this. The term smuggled migrant, the object of this offence, is further defined in paragraph J of Section 2 to mean any person in relation to whom one of the offences under this Act is committed, irrespective of the fact whether or not the perpetrator is identified, apprehended, prosecuted, or convicted. So independently of the perpetrator, the smuggled migrant is defined here separately. The Prevention of Smuggling of Migrants Act of 2018 has created three new basic offences for Pakistani law. Section 3 makes it an offence to smuggle migrants, which means intentionally or attempting to facilitate the illegal entry of a foreigner into Pakistan or another country, or a Pakistani national into another country, and this must be done for benefit. The second offence in Section 4 relates to the use of documents, where a person intentionally or attempts to produce, procure, provide, or possess documents that are used to smuggle migrants, again for the purpose of making a benefit. Once more, the focus is of those who are smuggling or providing these documents or possessing them on behalf of other people, not on the smuggled migrants themselves. A third offence under Section 4 relates to harbouring or accommodating or hiding smuggled migrants. The offence requires intentionally harbouring a person who is illegally in Pakistan, and again for the purpose of benefit. So it is the person who is providing this sort of shelter or hiding the person, and not on the person who is sheltered, that is the smuggled migrants. These three basic offences under Sections 3, 4, and 5 are aggravated, that means the penalty is raised severely, in the circumstances set out in Section 6 of this Act. This includes situations where serious injury is done to the smuggled migrants, or where they contract a life-threatening illness as a result of the perpetrator's conduct, where their death is caused, or where their life or safety are endangered. Aggravations also apply in circumstances involving cruel, inhuman, or degrading treatment, or situations that involve or are done by organized criminal groups, a point I will return to on the next slide. Liability for these offences is extended beyond the completion of the offences to situations where someone merely attempts to smuggle migrants or use an offence in relation to smuggling of migrants, where people are abetting any of these offences or conspiring to commit them. Section 7 criminalizes these two latter situations. The Prevention of Smuggling of Migrants Act of 2018 is of particular importance in situations involving organized criminal groups. This term is defined in Section 2, paragraph G, as a structured group of two or more persons acting in concert for benefit with the aim of committing any offense under this Act. This definition is quite broad and captures both more mafia syndicate style organizations as well as loose networks of multiple people who operate in conjunction for this particular purpose. If an organized criminal group is involved in the smuggling of migrants, in the offenses related to documents, or in the harboring offense, then one of these aggravations applies in Article 6, paragraph C, and it means that the penalty rate is raised to 5 to 14 years of imprisonment or a fine of up to 2 million rupee. There are very important exemptions and limitations to the criminalization under this Act. These concern, firstly, the smuggled migrants. Section 8 expressly says that smuggled migrants shall not become liable to criminal prosecution for the fact of having been the object of an offense under this Act. This means specifically that there is no liability for being smuggled. There is no liability for seeking to contact smugglers. And there is no liability for the smuggled migrant as the participant in the smuggler's offense. Smuggled migrants may, however, be liable for offenses under other laws. Limitations also apply to the smugglers by virtue of the benefit element, which is the purpose of smuggling of migrants as defined in Section 2, paragraph A. It means that liability is limited to those seeking to profit, in particular to make money, but as we've seen, also those seeking other benefits out of this activity. This does mean, importantly, that there is no liability for humanitarian or altruistic assistance provided to migrants, for non-governmental organizations or international aid agencies who help refugees or others who might be in irregular situations. Furthermore, there is no liability for family members who render assistance that is not done for benefit. Let me give you one case example to show how this legislation applies. The example involves a person from Myanmar who flees to neighboring Bangladesh across the border. This person then, finally, some quick words about the implications for law enforcement. Importantly, Section 11 gives the mandate over these offences, which are cross-border offences, to the FIA, but it also extends to the harbouring and offences relating to documents that may have been committed completely within Pakistan. Because many of these situations involve cross-border movement, cooperation is key. And the Act particularly mandates cooperation within Pakistan, but also across Pakistan's borders with countries of origin, transit and destination, and cooperation with international authorities and organizations who may be based in Pakistan or who may have a presence elsewhere. Also important for law enforcement is the fact that smuggled migrants may be important witnesses, a circumstance that's recognized in Section 8 of the Act. It means that they may require witness protection. It may mean that they require assurances to cooperate with law enforcement because they too may be in fear of repatriation to another place or to be the subject of revenge actions by the smugglers. In conclusion, let me summarize some key points. This new Act is about criminalizing and punishing those who smuggle migrants. The focus is on those who seek to benefit from another person's irregular migration. Penalties are higher, offences are aggravated if the persons are harmed, endangered, or maltreated. Special provisions also apply for the involvement of organized criminal groups. Being smuggled is not an offense. The focus is on the smuggler, not the smuggled migrants. And indeed, smuggled migrants may require protection and may be important witnesses for the case that the prosecutor may be building. This brings to an end the short outline of Pakistan's new Prevention of Smuggling of Migrants Act of 2018. Thank you for your attention.